A very good afternoon to our eminent Professor Doctor and our fellow friends in the room. It is my pleasure to welcome you all to this presentation on Act 780 from Laws of Malaysia, the BERNAMA Act 1967. Today, we will be delving into the history, background, and significance of this important piece of legislation, as well as exploring its relevance in the current media landscape. As you are all aware, the media plays a vital role in shaping public opinion and informing citizens about important events and issues. In this regard, the BERNAMA Act 1967 provides a framework for ensuring that news and information is accurate, impartial, and ethical, and that journalists and news agencies are held accountable for their actions. Through our discussion today, we hope to provide you with a deeper understanding of the BERNAMA Act 1967 and its role in promoting responsible and ethical journalism. We also welcome your questions and feedback and hope this presentation will contribute to ongoing discussion about the importance of press freedom and media ethics. Thank you for joining us, and we look forward to an engaging and informative discussion. For a quick jog down, we present you the table of content here. First and foremost, allow me to dip into the brief history of the BERNAMA Act. The BERNAMA Act 1967 is a Malaysian law that established the Malaysian National News Agency, also known as BERNAMA. The law was enacted on 30th August 1967 and provides for the operation, management, and function of BERNAMA. The main concern of the BERNAMA Act was to create a national news agency that would provide accurate and reliable news to the Malaysian public. Prior to the enactment of the law, there were several news agencies operating in Malaysia, but they were mostly foreign-owned and did not always prioritize the interest of Malaysia. The BERNAMA Act established BERNAMA as a government-owned news agency, with the primary objective of providing news and information about Malaysia to the public. The agency was tasked with collecting and disseminating news on politics, economics, social issues, and other areas of national interest. It was also given the responsibility of promoting a positive image of Malaysia, both domestically and internationally. The enactment of the BERNAMA Act was seen as a significant step towards the development of an independent Malaysian media and towards ensuring that the Malaysian public had access to accurate and reliable news. It also played a key role in promoting the country's national interest and protecting its sovereignty by ensuring that news coverage reflected Malaysian perspectives. Overall, the BERNAMA Act 1967 was enacted with the aim of establishing a national news agency that would serve the interest of Malaysia and its people by providing reliable and accurate news coverage of local and international events. As quoted by Hannah Arendt, there can be no rule of law without a sense of purpose. So, let us take a brief look into the purpose of the law we are discussing on. The purpose of the BERNAMA Act 1967, as stated in its long title, is to establish and incorporate the Pertubuhan Berita Nasional Malaysia, or Malaysian National News Agency, and to provide for the management and supervision of BERNAMA and other matters connected therewith. The Act was enacted with the following key objectives. Firstly, to establish a national news agency. The Act aimed to establish BERNAMA as a national news agency that would be responsible for collecting and disseminating news and information on matters of public interest in Malaysia. The agency would be tasked with providing accurate and reliable news coverage on a wide range of topics, including politics, economics, social issues, and other areas of the national interest. Secondly, to provide for the management and supervision of BERNAMA. The Act provided for the management and supervision of BERNAMA, including its organizational structure, functions, and responsibilities. It also established a board of directors to oversee the agency's operation and ensure that it operated in accordance with the objectives and mission. On the other hand, it is also enacted to promote national interest and protect sovereignty. The Act aimed to promote the national interest of Malaysia by ensuring that news coverage reflected Malaysian perspective and values. It also aimed to protect the sovereignty of the country by providing accurate and reliable news coverage on issues that affected Malaysia's interest and security. Finally, it is to promote professionalism and independence in journalism. The Act aimed to promote professionalism and independence in journalism by ensuring that BERNAMA operated with integrity and impartiality. The agency was expected to maintain high standard of journalistic ethics and to provide accurate and reliable news coverage that was free from bias or influence. Overall, the BERNAMA Act 1967 was enacted to establish a national news agency that would serve in interest of Malaysia and its people by providing news coverage of local and international events. It aimed to promote professionalism, independence, and integrity in journalism, and also to protect the sovereignty of the country by ensuring that the news coverage reflected Malaysian perspectives and values. There are total 5 parts as followed by the sections under the provisions included in BERNAMA Act, which encompasses Part 1, Preliminary, Part 2, Establishment of BERNAMA, its powers and objects, Part 3, Acts for Board of Governors, Part 4 is for Supervisory Council, and lastly, Part 5 is related to general provisions. Well, are there any amendments to the BERNAMA Act of 1967? Yes, there have been amendments to the BERNAMA Act 1967 since its enactment in 1967. The most significant amendments to the Act were made in years. These amendments introduced several changes to the Act, including the BERNAMA Amendment Act 1982. This amendment added a new section to the Act, which is Section 8A, which requires BERNAMA to comply with government directive related to the dissemination of news. Followed by BERNAMA Amendment Act 1988. This amendment made several changes to the Act, including expanding the definition of news and adding new provisions related to the appointment and termination of employees. Thirdly, BERNAMA Amendment Act 1995. This amendment made changes to the Act related to the appointment of the Director General and the composition of the Board of Directors. Followed by BERNAMA Amendment Act 2002. This amendment added new provisions related to the financial management of BERNAMA, including requirements for annual audits and the submission of financial reports. and also BERNAMA Amendment Act 2007. This amendment added new provisions related to the appointment and powers of the Audit Committee, as well as requirements for the submission of annual reports and financial statements. Overall, these amendments have helped to modernize and update the BERNAMA Act to reflect changing circumstances and prioritize over time. Not forgetting the BERNAMA Amendment Act 2018, which came into force on 2nd March 2018. This amendment updated on provisions of the original BERNAMA Act 1967 to reflect the changes in media landscape and the increasing use of digital technology. The key changes included expanding the definition of news to include digital content, empowering BERNAMA to provide news services in any form or medium, and allowing BERNAMA to engage in commercial activities related to news distributions and disseminations. Overall, the BERNAMA Amendment Acts are aimed to ensure that BERNAMA remained relevant and effective in the changing media landscape. The amendment introduced through this act have enabled BERNAMA to expand its operations and to provide news and information services on various platforms, while also ensuring greater accountability and transparency in the agency's operation. We have addressed about the BERNAMA Act's history and legacy. Following that, we will move on to additional contemporary legal subjects. So, we'll begin with offense elements in the BERNAMA Act of 1967 or the Code of Ethics. The BERNAMA Act 1967 and its amendments do not specifically outline offenses and penalties. However, the Act and its subsequent amendments provide guidelines and expectations for the operations and conduct of BERNAMA as a national news agency. Violations of these guidelines may result in disciplinary action or legal consequences. The BERNAMA Act 1967 and its subsequent amendments establishes the following expectations for BERNAMA's operations. Number 1. Objectivity and accuracy. BERNAMA is expected to provide news and information that is accurate, reliable, and objective. It must not distort facts or prevent biased or one-sided reporting. Next, national interest. BERNAMA is expected to provide news and information that reflects and promotes the national interest of Malaysia. It must not publish material that is detrimental to national security, public order, or public morality. Followed by professional conduct. BERNAMA employees are expected to conduct themselves in a professional and ethical manner. They must not engage in conduct that may damage the reputation of BERNAMA or the country. Lastly, supervision and management. The minister responsible for BERNAMA has the power to supervise and manage the operations of the agency. The minister can issue directive or instructions to ensure that BERNAMA operates in accordance with the Act and its amendments. Violating any of these expectations can result in disciplinary action, ranging from a warning to termination of employment. Additionally, if BERNAMA violates any of these expectations in a way that causes harm to an individual or group, legal consequences may also arise, such as a defamation lawsuit or a charge under Malaysian media laws. Although there were no specific offences or penalties, we can see some of the sections that play a major role to take disciplinary actions against anyone who oversees the paras. Firstly, Section 22, Clause 1 of the BERNAMA Act provides for verbal or written warnings to be issued to an employee who has committed a minor offense. For example, if an employee is repeatedly late for work or fails to follow a particular office procedure, they may be given a verbal or written warning. Followed by Section 22 Clause 2 of the BERNAMA Act, which allows for an employee to be suspended for a period of time for more serious offences. For example, if an employee is found to have engaged in unethical behavior, such as expecting bribes or leaking confidential information, they may be suspended pending an investigation. On the other hand, Section 22 Clause 3 of the BERNAMA Act allows for an employee to be demoted for serious misconduct or repeated offences. For example, if an employee repeatedly fails to meet their performance targets or engage in inappropriate behavior, they may be demoted to a lower position. Lastly, Section 23 of the BERNAMA Act provides for an employee to be dismissed from employment for serious misconduct or a serious breach of discipline. For example, if an employee is found to have engaged in illegal activity or committed a serious violation of company policy, they may be dismissed from employment. Now, it's worth noting that the specific disciplinary action that can be taken may depend on the nature and severity of the offense, as well as mitigating circumstance. The BERNAMA Act also provides for an appeal process whereby an employee may appeal against any disciplinary action taken against them. There are some of the key elements of the Code of Ethics, along with the corresponding sections of the BERNAMA Act. First and foremost, accuracy and reliability. Section 9 of the BERNAMA Act requires the agency to provide accurate and reliable news, while Section 13 provides the guidelines for the verification of the news and sources. Secondly, impartiality and fairness. Section 10 of the BERNAMA Act requires the agency to provide and to be impartial in its reporting, while Section 11 providing guidance for the avoidance of bias and the inclusion of diverse perspectives. Thirdly, privacy and confidentiality. Section 15 of the BERNAMA Act prohibits the disclosure of confidential information related to the agency's operation, while Section 12 provides guidelines for the protection of privacy and the avoidance of intrusive reporting. Lastly, professionalism and integrity. Section 16 of the BERNAMA Act requires all employees to conduct themselves in a professional and ethical manner, while Section 17 provides guidelines for the avoidance of conflicts and interest and the disclosure of potential biases and affiliations. It is important to note that while these elements are not explicitly listed as offences in the BERNAMA Act, violations of the Code of Ethics can result in disciplinary actions or other consequences for employees. Before we move on to the next segment of our presentation, I would like to take a brief pause and let my teammate to take the floor. I will remain here and actively participate in the discussion once he finishes. Thank you for your attention and please welcome my teammate.
Assalamualaikum everyone. My name is Akmal 286774. Related cases from the news journals. According to the Malaysian judicial website, kehakiman.gov.my/, various cases are mentioned under the BERNAMA Act 7. First one, in 2013, a former BERNAMA journalist sued the news agency for wrongful dismissal claiming that the agency had breached the terms of his employment contract. The case was handled under Section 14 of the BERNAMA Act, which deals with the appointment and termination of BERNAMA employees. Let us take this case for example. Wrongful dismissal occurs when an employer terminates an employee's contract of employment in breach of the terms of the contract or in breach of the law. In such cases, the employee may have the right to sue the employer for damage or to seek reinstatement of their job. Section 14 of the BERNAMA Act deals with the appointment and termination of BERNAMA employees. This section provides guidelines on the procedure that must be followed when hiring and firing employees of the news agency. Specifically, it requires the agency to adhere to the terms of the employee's contract and to provide proper notice of termination if an employee is being dismissed. Based on the limited information available, it appears that the former BERNAMA journalist in question claimed that the news agency breached the terms of his employment contract when they terminated his employment. As a result, he sued the agency for wrongful dismissal under Section 14 of the BERNAMA Act. Second, on the other hand, in 2015, BERNAMA was accused of publishing false news about the Malaysian government's handling of the MH370 disappearance. The case was investigated under Section 9 of the BERNAMA Act, which requires the agency to provide accurate and reliable news. In 2015, BERNAMA, the Malaysian National News Agency, was accused of publishing false news about the Malaysian government's handling of the MH370 airplane disappearance. The news agency had reported that the government had received satellite data that could help locate the missing plane, but the report was later found to be untrue. The case was investigated under Section 9 of the BERNAMA Act, which requires the news agency to provide accurate and reliable news. This section specifies that BERNAMA has a duty to provide news that is truthful and impartial, and to ensure that its reports are based on accuracy and sound journalistic principles. The investigation was carried out by the Malaysian Communication and Multimedia Commission (MCMC), which regulates the media industry in Malaysia. The MCMC found that BERNAMA had violated Section 9 of the BERNAMA Act by publishing false news and issued a warning to the agency. The case received widespread media attention and criticism, with many accusing BERNAMA of failing in its duty as a news agency to provide accurate and reliable news. Some also argued that the incident highlighted the need for greater regulation of the media industry in Malaysia and for stricter enforcement of laws such as the BERNAMA Act. The case also highlights the need for greater accountability and transparency in the media industry, particularly in cases where false news is published. Finally, the case underscores the importance of upholding the journalistic principles and ensuring that news reports are based on factual accuracy rather than sensationalism or political bias. The third one. In 2019, a former BERNAMA editor was charged with leaking confidential information related to the agency's operations to a third party. The case was handled under Section 15 of the BERNAMA Act, which prohibits the disclosure of confidential information. Section 15 of the BERNAMA Act states that no person who has been entrusted with any confidential information relating to the affairs of BERNAMA shall disclose such information to any person without the permission of BERNAMA. Violation of this section is considered a criminal offense and can result in fines and imprisonment. The former Bernama editor was accused of leaking confidential information to a third party without the permission of the news agency. The information in question related to the agency's operations, including its financial and administrative affairs. The case received widespread attention in the media, with many criticizing the former editor for breaching the trust of his former employer. Some argued that the case underscored the importance of maintaining confidentiality in the workplace and the need for employees to be held accountable for the action. The case also highlights the need for employers to take steps to protect confidential information, such as implementing policies and procedures to safeguard sensitive data, and monitoring employee behavior to detect potential breaches. Finally, the case underscores the importance of upholding the law and holding individuals accountable for their actions, particularly in cases where confidential information is at stake. In 2020, a Malaysian opposition politician filed a lawsuit against Bernama and several other news agencies for defamation, claiming that they had published false and defamatory articles about him. The, the case is being handled under the Malaysian Defamation Act 1957, which provides for civil remedies for defamation. The politician claimed that the news agency had published false and defamatory articles about him, which had caused damage to his reputation. The case is being handled under the Malaysian Defamation Act 1957, which provides for civil remedies for defamation. Under the Act, a person who has been defamed may bring a civil lawsuit against the person or entity responsible for the defamation and seek damage for any harm caused. In this case, the opposition politician is seeking damage from Bernama and other news agencies for the harm caused by the alleged defamatory articles. The politician has argued that the articles were published with the intention of damaging his reputation and that they contain false and misleading information. The case is currently ongoing and it remains to be seen what the outcome will be. The case highlights the potential impact of defamation on an individual's reputation and the importance of laws such as the Malaysian Defamation Act 1957 in protecting individuals from false and harmful statements. The case also underscores the need for media organizations to exercise diligence in verifying the accuracy of their reports and avoiding the publication of false or misleading information. Finally, the case highlights the importance of protecting the rights of individuals and ensuring that they have access to legal remedies when their reputation is harmed by defamatory statements. In 2021, Bernama came under scrutiny for its coverage of the COVID-19 pandemic in Malaysia, with critics accusing the news agency of bias, reporting, and spreading misinformation. The issue was addressed under Section 9 of the Act, which requires the agency to provide accurate and reliable news. The issue was addressed under Section 9 of the BERNAMA Act, which requires the agency to provide accurate and reliable news. The Act specifies that the agency must endeavor to disseminate news which is accurate and impartial and shall not knowingly publish any false or misleading news. In response to the criticism, Bernama issued a statement reaffirming its commitment to providing accurate and reliable news and pledged to investigate any reports of biased reporting or misinformation. The agency also emphasized the importance of responsible journalism in ensuring public trust and confidence in the media. The case highlights the importance of media organizations adhering to standards of accuracy and impartiality, and the potential risks of biased reporting or misinformation. The issue also underscores the need for media organizations to be accountable to the public and to take steps to address concerns or criticisms of their reporting. Finally, the case highlights the ongoing challenge of managing the COVID-19 pandemic and the important role that accurate and reliable news can play in supporting public health efforts and promoting public trust in government and the media. In conclusion, the BERNAMA Act plays a crucial role in regulating the operation and functions of the Malaysian National News Agency. It provides a framework for the appointment and termination of employees, requires the agency to provide accurate and reliable news, prohibits the disclosure of confidential information, and establishes the agency's legal responsibilities. The case involving the BERNAMA Act, as outlined above, illustrate the importance of his legislation in ensuring the proper functioning of the news agency. It is therefore essential that the Act is enforced and upheld in order to maintain the integrity of the news industry in Malaysia. Relevancy of BERNAMA Act 1967 in current situation. The BERNAMA Act 1967 remains highly relevant in the current situation, particularly as Malaysia and the world face ongoing challenge in maintaining press freedom and ethical journalism. The Act serves as a framework for regulating the operation and conduct of BERNAMA and provides guidance on key areas such as news dissemination, employee appointments and terminations, and the handling of confidential information. The Act's provisions on the dissemination of accurate and reliable news are particularly relevant in the current era of and misinformation, where the credibility and integrity of news organizations are increasingly being called into question. By requiring BERNAMA to provide accurate and impartial news, the Act helps to ensure that the agency upholds high standards of journalism and supports the public's right to accurate and reliable information. Firstly, the Act provides for the establishment and incorporation of the National News Agency of Malaysia with the mandate to gather, process and disseminate news and information in a professional, accurate and impartial manner. In today's fast-paced and ever-changing media landscape, where disinformation and fake news can spread rapidly, the need for reliable and trustworthy news agency is more important than ever. Secondly, the Act establishes a code of ethics for journalists and sets out specific offences related to the dissemination of false news or information. This helps to ensure that journalism is conducted in a responsible and ethical manner and that the public can trust the information they receive from news sources. Thirdly, the Act provides for the management and supervision of the National News Agency of Malaysia, which helps to ensure that the agency operates in an efficient and effective manner and that its activities are transparent and accountable. In light of recent events such as COVID-19 pandemic, there has been an increased demand for reliable news and information, as well as over the spread of misinformation and disinformation. The BERNAMA Act 1967 provides a framework for ensuring that news and information is accurate, impartial and ethical, and that journalists and news agencies are held accountable for their action. The Act's provision on employee appointments and termination are also relevant in the current and future context of workforce management. As organizations adapt to changing market conditions and technologies, it becomes increasingly important to have clear guidelines on how to hire and terminate employees in a fair and transparent manner. The BERNAMA Act provides such guidelines and can help to ensure that the agency maintains a skilled and effective workforce. The Act's provisions on confidential information are highly relevant in the current era of cybersecurity threats and data breaches. By providing clear guidelines on the handling of confidential information, the Act helps to ensure that BERNAMA maintains the confidentiality of sensitive information and protects it from unauthorized disclosure. Overall, the BERNAMA Act 1967 remains highly relevant for the current and future usage of the Malaysian National News Agency and can help to ensure that the agency upholds high standards of journalism, maintains a skilled and effective workforce, and protects sensitive information from unauthorized disclosure. However, it is also important to note that the Act should not be used as a tool to stifle free speech or silence critical voice. As with any legislation, the Act should be applied in a fair and just manner and should not be used as a means of censorship or suppression. In this regard, it is important for stakeholders to engage in ongoing dialogue and consultation to ensure that the Act remains relevant and effective in meeting the needs of society in an ever-changing media landscape. So that's all. Thank you.
Thank you for joining us today. This brings us to the end of our presentation. On behalf of my colleague Muhammad Shafiq Akmal bin Romzi and myself Praveen Kumar Jaywanan, we appreciate your time and attention. If you have any further questions or comments, please do not hesitate to use the form. Once again, thank you and have a great day.